All is well that ends well. Mr. Mahat will give the explanation. Thank you very much, Milady.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and Associate Justice of Supreme Court, I wish to respond to three very quick issues that were raised by my learned colleague, Ms. Julie Soweto. The first one relates to a form that was shown this court. I would want the form to be projected. We will. Whatever that was projected from the portal, that is what we want the court to see. What Ms. Julie Soweto showed. You could go, please go to Jose Carmago. I want to produce to the court the original form 34A.
It's okay.
Yes, you can see. It's okay. I want to produce the form 34A, the original form 34A, and I want to inform the court that the name Jose Carmago on that form is an overlay. Jose Carmago, the register of the QR code, that was printed by Smartmatic International, and it was printed in the name of Jose Carmago. You can show? The register is available.
We were very patient the way Mr. Mohammed addressed the court earlier. Very, very persuasive. But for good order and not to interfere with his submissions, we kept quiet. And if you look back at the record, a lot of what Mr. Mahat was saying was actually giving evidence. He was talking using the word we. This is how we do it. The trajectory which he is taking, without a witness to tell us the kind of information he's going to give us, is going to put the court in a very difficult position. I think he should transform himself to a witness and we begin to cross-examine him. Because, and this is very serious, either we practice law the way we understand the law, or anybody can confront the court with any document at any time. I understood Mrs. Soweto to be giving an explanation in response to a question by the court. And similarly, Mr. Mohammed was responding to question by the court. And therefore, he had some latitude. But now we are entering a different universe where he is now going to produce evidence. He is saying how the picture was taken. There is no certificate, and this is electronic evidence accompanied by an original. I think it is very, very dangerous territory. And unless some clarity is given on this matter, it is going to be very difficult to operate from now.
My lords, what we are trying to do is to show you documents in our own affidavits in response to documents produced from the bar. Ms. Soweto never produced the document she showed you in any of her affidavits. When we now invite you to look at the original and to make the argument that my learned friend is about to make, that there is a deliberate misrepresentation of what the original document looked like. So we are treated to this attempt to block that fact from the court. This is not a legitimate objection. This is an attempt to interfere with legitimate evidence that is on record.
Let's give it directions, because we'll be here until tomorrow and we don't have this time. Senior counsel.
Yeah, just one point. And I'm normally very quiet, and I continue to be very quiet. But the good professor has misunderstood Ms. Soweto completely. it is not this document which is in question. It's the way the interference is being done, how this document is changed to another document twice or thrice, 3 times. I think the good professor will be doing a good service to the court. And if he is good coming to court with clean hands, he should first of all say, Mrs. Soweto, what Mrs. Soweto showed us today is not in their portal. That is the starting point.
Isn't that exactly
that is the starting point.
Bear with us, Senior Counsel. We've come thus far with a lot of discipline and dignity and respect to the court. The reason why we are here, and you saw, has taken a lot of time to reflect on the application that was made by, I think he started with Mr. Katwa Kigen, Mr. Kirago, and Mr. Ngatia. We resisted until we established from the pleadings that we have that these are new forms. And indeed, they are entitled to respond to them. So please, if you can just respond without taking us into anything else, just respond to those new forms, because they were not part of the ones that we have before us. We established that.
Thank you so much, Madam Chief Justice and members of the court. The difficulty we were facing in thinking about this, an allegation has been made as relates to this form, and there's an overlay of someone called Mr. Jose Carmago. What we were trying to show the court, that this is an overlay document, and we wanted to actually show the court where this document from Jose Carmago has come from. The document relating to Jose Carmago has come from the QR register, which is distributed to every polling station. And that document is even in the possession of this court. If you look at the scrutiny report, the QR documents are there. So what happened? Apio took an original Form 34A, he had the QR register, and he took a picture of it. What is the evidence that is being given in this court? That someone called Jose Carmago is interfering with this. And the point we want to make to this court is that if you look at the scrutiny report and if you look at the QR register, which is in those boxes, you will actually find the name of Jose Carmago on the register that has been printed. We've also produced the original Form 34A. We've come with the receipt. And we're being told that you cannot produce your original 34A, that Jose Carmago was interfering. And in fact, if you look at the numbers on the original 34A, it's the same as what the picture of the overlay was taken. So to the question that someone called Jose Carmago was interfering with the portal, it's actually not true. It's incorrect. And the attempt to prevent that evidence to the court is should actually guide the court that actually that is not true. Why would anyone try to interfere with a portal transmitting, and the result he has is the same as what is in the A and what is in the portal? So to that question, we submit that that is not true, and that is an overlay that someone who has taken the picture. We will give the court the Form 34A to compare with the original 34A with the certified copy that the court has. And in fact, we direct the court to the scrutiny documents. That register of opening and closing the KIM is there, and the name of Jose Carmago for purposes of audit trail is printed in there. Smartmatic Jose Carmago is printed there. So what has happened? Someone, Apio, took a picture on that one. The next point I want to make is the issue of the KIMs. We've been told there are 2 KIMs kit, which had the same serial number. And we understood our role to this court to give all the information to the court to make a decision. We admit that those KIMs have the same serial number. It was an error that originated at the time of the serialization. But we want to tell the court that those KIMs have different IMEI, they have different IP addresses, they have different polling stations, they have so they have different identifiers. And we acknowledge that that is an error that originated relating to those 2 KIMs. But there are other identifiers that can identify those KIMs are from our system. And we want to give that information to the court for purposes. Those KIMs are on their way to this court. We will give to the registrar of the court for the court to analyze and to look at it. And if you look at those KIMs, they transmitted the forms as required in the portal, and the A's also are coming, the original A's, we will also give for those 3 forms. And our role is to give. The issue of transmission has come up. I just want to say this. There were 3 sets of transmissions at Bomas. One on the forms that has been downloaded, that was running properly. The second one related to the constituencies, that was continuing. The one which had stopped was the one on the tally. And the reason it stopped was, for 3 days, we had only verified 50 arrows. The process became clogged. For you to be able to transmit to the announcement, verification had to happen, then announcement happens. That means that those arrows have to be stopped, because verification cannot happen as announcement is happening. We will be running numbers that have not been announced yet. So because of that, and because of the audit, forensic audit that most of the agents were recommending, we had to stop that process to give verification a chance. There was nothing malicious about that. For those few remarks, Your Ladyship, I stand guided. Thank you.
Mr. Mahat, maybe we can have a look at the
My lady,
original
if the
34 that you are showing.
Sorry, my lady, Chief Justice, if the form can be handed over to the court. Excuse me. A moment. Thank you. Thank you. My lady, my learned friend, Senior Counsel Murgor, has a comment after the court has seen the...
As you continue to look, we'd just like to make an observation. In fact, we are happy that the court receives the document, particularly the Form 34A, and everyone has been quoting Shakespeare and all the rest. I'll just quote some Swahili. Siku ya nyani kufa, miti yote huteleza. If you notice on the 34A, the UDA agent, the second agent, signed the form on the 7th of August, 2022, before the election. Before the election. I repeat, before the election. The other one as well, perhaps might have signed it on the 7th, but it's not clear. So that's all we wish to say.
While at it, Counsel, just before you go back, and when did the other agent sign?
It looks like 7th, it looks like 9th. Only the IBC and Mr. Chebukati can tell us. It is their evidence.
Before they explain, they would have to have something to explain.
We have let it go in.
This form, from the naked eye, of course, appears to have been signed by both agents on the same date. And the same date is 07.
Oh, 07 of 08.
07 of 08.
Yes, indeed.
See, well, I thought the point you were making was that the second one signed before the election. As though the first one, if I could just finish.
Okay.
As though the first one had signed on a different date.
No, our point is, and has always been, these forms may have been manufactured elsewhere, before, well after voting, and they all arise one day and they are counted. It is the mess that is IBC, and it is the mess that is the 2022 presidential election that we have been emphasizing. Thank you.
You still want to talk?
Madam Chief Justice, my client is the one who is likely to suffer most in case this sensational matters are not dealt with effectively. Starting with the date, that is more of drama than reality, is seeing a speck in the other person's eye when the log is in the other person's eye. One of the things I think I ought to place on record is this. The forms that are now in issue have not been pleaded, were not tendered, and since they were not pleaded and they were not tendered, we should not be accused of not having responded to them. Point number two, both agents have made a legitimate or have made an innocent mistake about the date. And I don't see where the laughter is emanating from. Point number three, the form itself shows a contrary position to that which was sensationally displayed before this court. The sensational reporting that was made was intended to convey a picture which is to the opposite of what the form now before the court conveys. And that reminds me of that very unfortunate day in 2017 at 9 p.m. that again sensational claims were made about forms 34B from Mombasa, in particular Shangamwe, made also to this court and which led to a nullification of a presidential contest. Madam CJ, there is also one more thing that concerns my client, because again, it has very prejudicial effect. It is what is definition of the commission. I will spend 1 or 2 minutes defining the various ways commission is defined in the law. Commission is first and foremost defined in Article 88. Commission is also defined
if we open the matter now to other things, we will not see an end to this. You were responding to the two forms which were introduced.
As new evidence.
Yes, please don't go to other things that you are not supposed to, because we will not see an end to this.
I still have my time.
With respect, even if you have your time. Even if you have your time.
Thank you.
Just deal with the two forms.
So then, coming back to the forms, my request is this. Please delete from the... yes, the other thing is that the form now before you has security features. The one that was displayed does not have. The one that you have does not have the name of Jose Carmago. The one that was displayed before the court has that name of Jose Carmago. The original one you now have does not have that name. And all those things were meant to deceive. They were meant to mislead.
We should never have to ask that we remain the way we started. We should never have to ask that.
Particularly from such eminent lawyers. The one that you have does not have any of those things that were displayed. My client therefore becomes quite concerned whether this case is to be adjudicated in the realm of falsehoods or within the parameters of factual contestations. That is a real concern. The minute we allow matters which are clearly false to infiltrate into the record of this court, we are likely to get into a very, very unfair decision. Let this case be decided on factual points and on factual contestations. We say the same about the second form, that the original has not been provided. But as regards the second one, allow me to say this. Before this contest started, IEBC did avail to this honorable court all the forms 34 A's, all of them were deposited because we did see that correspondence. Consequently, as regards the second form, I would request this Honorable Court to find time to look for it, the certified copy, and in case, once again, it does not have this JAWS, whatever name it is, please come to this conclusion, that a deliberate effort was made by counsel to mislead this court so as to arrive at a decision which would be most injurious to the first and second respondents. I'm very grateful for the 5 minutes, and I rest.
Thank you very much. With your permission, we would like to go to another segment of these proceedings, the last of them, where we'll be considering the report from the scrutiny or the discovery that was undertaken by the court, and I'll ask the Honorable Lady Justice Joaquin Dongo to take us through that session.
Thank you very much, Madam President Judge. Before I come to the issue of the exercise before us, I just wanted to assure Senior Counsel Paul Mwite that when the 14 days start running, and we are guided by Article 259, when we do work Saturdays and Sundays. So as soon as the time is triggered, in fact, the judges are working all the time. You're the ones who get to go home and rest. When you rest, we go and we continue to work. Thank you very much. So just before we proceed with the next session, it was just a summary of the order that we gave to parties and the rationale for those orders. We received 3 applications from 3 parties, from the Youth Advocacy Africa. We received an application from Khelef Khalifa, and we also received an application by Raila Odinga and Martha Karua, in which we were asked, the press was sought to undertake scrutiny and access to certain information. After we looked at the applications and the prayers, we then looked at the pleadings and the affidavits to ensure that the prayers matched with the pleadings and the affidavits that have been filed by the petitioners. As you will recall, the court then determined the issues which we will determine, and that also helped us set out the orders for scrutiny, so that our orders were set out based on the pleadings, the affidavits, the issues for determination. But further to that, we also did say in the body of our order that we would not encourage a fishing expedition, and that the request needed to be specific, and that given the 14-day timeline, the court would only allow reasonable, practical, and helpful orders. We also acknowledged that under Section 12 of the Supreme Court Act, the IEBC has already submitted all the Form 34As, and therefore they could be accessed in the court. We also stated that some other issues, some other things that had been requested for in the prayers are in the public domain, and that parties could then get those. We did note that some of the requests or the prayers were unrealistic. Some of them were general and vague. Some of them involved parties that were not enjoined to be before us. And therefore, we granted orders not based on prayers, but based on what we assessed that the court needed to look at in terms of all those criteria that I have set out. And therefore, the exercise that was conducted under the hand of the registrar followed strictly the orders which were given under the hand of this court using that criteria. I think that is a fair summary. Madam Judge President, I will stop there.
Thank you. I think an exercise was carried out, a very rigorous exercise led by our registrar. Indeed, these are people who had not slept for 24 hours working to carry out this exercise of ensuring that there is compliance with the orders of this court. Our staff actually spent a night here. They had to shower somewhere here and continue working yesterday morning. So the report has been shared with Council online, and because the parties who are involved in the requests for the discovery is the main petitioner, the Youth for Advocacy, and the petitioner Karif. We have decided to allocate each one of you 15 minutes to submit on any issues you like us to take note of in the report. That is the main petitioner, 15 minutes. Youth Advocacy for Africa, 15 minutes. Karifa, 15 minutes. Then we will have IMBC, 15 minutes. And because the first respondent is also affected by what is being discussed in the report, we also agreed to give them 15 minutes. Yes, you have the floor.
Thank you very much, Your Ladyships and my Lord. I'll be as quick as possible, and I would like to indicate that I will share the time with my colleague Jackson Awele, who will deal with what happened at Forodha, while I will deal with everything that happened at IBC Anniversary Towers. The report the court has given runs into 178 pages, but we worked overnight to provide written observations to the court, which we filed this morning, and so all parties are actually aware of whatever it is the first and second respondents, petitioners have observed. Very quickly, IBC confirmed that the RTS, the results transmission system, runs on 8 servers, of which one is a virtual server.
Counsel?
Yes?
You say you filed something?
Yes, we filed written observations with court, and we have a few copies.
Just wait until we get our copies. Are they in the bank?
We filed them
just
before.
Give us
okay.
A moment there. Yes. If you say you have extra copies, you could give us, yes, so as to save on time.
Yes,
we do not have a copy. If Learned Counsel could be kind enough and serve us a copy.
For the principal respondents, we can give you one of each.
This shows the time we are given to respond.
We served them before 9 o'clock this morning. Electronically. The only thing that there'll be a problem is some of the images will not be very clear, but when you do have time, the images at the end.
Just hold on, Councillor.
Okay.
You could start.
Yes, Jackson, you could also perhaps upload it so that those who don't have a copy can see where we're reading. I'll go to the first observation on page 2, summarize the first paragraph. IEBC confirmed that the results transmission system runs on 8 servers, of which 1 is a virtual server, and the 7 are Docker containers, which is a server within a server. The IEBC denied agents access to the Docker servers. We were therefore unable to proceed further with that exercise. Paragraph 2, the...
Council again.
Yes.
The copies you've given us are not filed.
They're not filed, the electronic ones are filed. I anticipated having to provide 1 or 2 people with copies, but the electronic ones are filed, very clear. We have a receipt.
Yeah. It's all right.
Okay.
Council, I think we had already given directions that we expect oral submissions.
I am making oral submissions.
Yes, so
Okay.
I'm just saying, let us not worry too much about written reports, who has served who.
Okay.
You're letting the court know what you think of the exercise so that we can take those submissions into consideration. And that should apply to all the other parties.
I stand guided. Thank you very much. I go to paragraph, or I'll just make it an oral submission. The virtual image availed for scrutiny was created on the 31st of August 2022. We therefore state that this cannot be from the same server that ran the just concluded general election. And the image of the server was not provided. The further major observation we make, the KIMS kit was not availed for scrutiny to establish the availability of the embedded scanner application that would verify the image format. So the IEBC declined to avail the system documentation. I go on. There was very disturbing evidence of log deletions from the IEBC server that was availed, in part, partially availed. These deletions occurred on the 6th of August 2022, which is 2 days before the contested election. We observe that, surprisingly, the registrar's report at page 21, issue number 5, indicates that there were no deletions. We think this is a mistake. It should be looked into. The effect of the deletions, we can upload that. It's on the screen now, that we were able to get from IEBC, indicates that, and this is image marked 15, that at the material time, foreigners, including Ogudino, Vito, J. Carmago, Josio, were operating the system. Those are 1, 2, 3, 4, 5 foreign individuals. If a forensic image of the server is availed, details of what was deleted would certainly be established. The other major observation, IEBC refused to provide a security walkthrough to highlight key security controls to determine whether Form 34A could be tampered with during transmission, at what point. So we hit a dead end, contrary to what their counsel repeatedly says. They are transparent, it's available. They are even giving the court, donating to the court KIMS kits to look through. Finally, or well, not finally, IEBC refused to grant access to the forensically imaged servers. Instead, the server administrator projected the vSphere, which is the Virtual Server Application Management System, on the whiteboard to demonstrate the access to the servers. The vSphere indicates that the virtual RTS server was created and modified on the 31st of August at 2022. In effect, no information from a server was provided to show what happened during the 2022 general election. Number 11, a couple of manuals were provided, or bundles of documents. We'd like to point out that of interest to the court would be that at page 77 of one of the manuals titled Information and Communication Technology ICT Policy, at page 77 and 78 is a list of 77, a list of 41 individuals, starting with Dixon Kwanusu, and second one Abdi Dahir Abdi Malim, who are described at the top of the page as national returning officers, an office unknown to the law or the Constitution. I would request that the court takes note of that in particular. And paragraph 14, on the 1st of September 2022, the deadlock over the servers finally came to a head when IBC wrote to the Registrar of the Supreme Court enclosing a letter dated 31st August 2022 from Smartmatic International BV, the same company that Carmago comes from, enclosing in which the letter states, amongst other reasons, the image of the NTC servers containing software owned and copyrighted by Smartmatic and thus IB protected. Providing full access would infringe our intellectual property rights. That brought to the end that matter. Smartmatic, Carmago, whoever they are, wherever they are from, have indicated that they will block and refuse access to the servers completely. I then move to the images. Certain images were shared by IBC. I'm not certain that they were aware of what they were serving. There was always a staff that seemed quite unqualified in whatever they were doing. They couldn't operate the systems or pretended they couldn't, but they did share image number 6. The first image I showed was the image of deletions, but the one I would like to focus on in this very limited time is image number 6, which is several, about 1, 2, 3, 4, 5 pages of logs. The logs are from the RTS server, results transmission system, on various days leading up to and after the election date of the 9th. In particular, 15th July 2022 to the 16th of August 2022. And I must apologize to bring the bad news not only to this court, but to the entire Republic, that those logs contain active participation of foreigners on the results transmission systems of IBC from the 15th to the 16th of August, 15th of July to the 16th of August 2022. Their names are Vito, Josio, that is the names identified in these logs, Josio, Ogudino, Sisiva, Provisio, and Jacamargo. The copies I provided to the court are much clearer, and you can see the names, you can see the times, and of interest, and I will only highlight certain entries, only the longest entries. I will start by saying those 1, 2, 3, 4, 5, 6 individuals, foreigners, in the Immigration Act they are also referred to as aliens, accessed this server 180 times or thereabouts. The longest being Carmago on the 8th of August 2022, Josio, let me deal with the time, Josio on the 9th of August 2022, which is the election day, for 1 hour 32 minutes, Ogudino on the 11th of August 2022, 2 hours 54 minutes, Ogudino again on the 11th of August, 3 hours 16 minutes, Ogudino on the 14th of August 2022 for 2 hours. Ogudino on the 4th of August again, 1 hour 57 minutes. And then the 16th of August, Ogudino, 1 hour 1 minute. I close by saying, what a mess, what a mess. My learned friend Mr. Ngatia struggled so hard to get Mr. Carmago out of the mess of taking control of our elections in the case of the 34A we've just been talking about, but we've caught Mr. Carmago and all his friends in our election process before, after, and where are they? Only God knows, and only the servers will show us. History is repeating itself. 2017, Mr. Chepkati refused to provide access to the servers. He's doing it again. And of course, please, I ask the court to take note of everything we have provided as far as the DCI has provided to us. We have provided to the court. These are individuals whose identities are not even known. They travel on, or they provide expired passports when interrogated by the police, and all the rest of it. I would not repeat any more of that. On the 8th of, yes, I'm happy to be pointed out, the logs will also show that on the 8th of August 2022, Carmago accessed the portal while in Venezuela. So our elections were conducted from Venezuela. The Venezuelans decided who won. Mr. Chepkati was just the mouthpiece. Thank you.
My Lady the Chief Justice, my Lady the Deputy Chief Justice, my lords, my ladies, in the remaining few minutes, permit me to take you through our report from the scrutiny exercise carried out at Forodha. And my lord, I'd like to very quickly just highlight sequentially in the order in which